So that was right. So.
Okay, let's find someone who's on Zoom. Ms. Rios, can you hear us here in the courtroom? Or Ms. Eaglin, can you hear us?
Yes, Your Honor, I may hear you.
We can hear you.
I can hear you.
Fantastic. All right, let us add Ms. Eaglin. Mr. Lewis, I think you are on. If you start talking, there you are. I see you. Let me add you. There's Mr. Lewis. And I need to know what booth Mr. And Ms. Feely is on. Look at all these folks. This is like a reunion session.
Yes,
But critically, we need Mr. Dill. Does anyone know what booth he is in?
yes, he's in 7 South Booth 3.
All right. Oh, I got to fire up that thing. Let's see here. My tool that opens the booths is here. You said 7 South, booth 3?
Yes, sir.
All right, 7 South, booth 3. Please work. Oh. All right. This. Sign in again.
These computers are not connected as well.
Oh, can you fix that?
I think you have to just
Which to the prosecution and defense? Okay, well, I don't think we'll need defense. I'll see if we can get prosecution. Otherwise, folks will have to schlep to the podium. But let's see if we can get the booth operator going. 7 South, booth 3. Please connect. Oh, yeah. That's promising. Got it. Got it. All right. Mr. Dill, can you, let me see if we add, there he is. I recognize him. Can you hear us, Mr. Dill?
yes.
Great. Finally, Ms. Rivers, can you hear us?
Yes, I can.
Okay. We are taking a brief diversion from our jail Zoom calendar to wrap up the motion for new trial hearing for Mr. Dill. It's 22 SC 181085. And we met yesterday for a good number of minutes to almost wrap up the motion for new trial hearing for Mr. Dill. And at the very end, something came up that prompted the state to want to recall Ms. Feely as a witness. I share the state's curiosity. So there's just a few questions for Ms. Feely. Both sides, of course, will have a chance to ask. But I think it's going to be Ms. Eaglin actually calling Ms. Feely. So she'll do her direct. If Mr. Lewis has any cross, he can do that. And I think that will close out the record in the Dill motion for new trial hearing. But I think that's where we left it. Mr. Lewis, do you agree that that's the status we're in, or anything you want to add?
No, sir.
Okay. Ms. Eaglin, anything you want to add, or is that where we left off?
That's where we left off.
Okay. Mr. Dill, we're just going to ask Ms. Feely a few questions. When that wraps up, then I will signal to the sheriff's team that you can be transported exactly where you want to go. Well, I shouldn't put it that way. You don't get to pick where, but you'll be going back where you came from. So we'll get you on your way. Ms. Eaglin, if you would.
Yes, Your Honor. For purposes of this hearing, do we need to re-swear in Ms. Feely?
We do, and Deputy Gordon, who hasn't sworn anyone in for like 8 days, is surging towards the screen right now to do that. Let me add the podium so he can be seen. There he is. I don't know if you guys recognize him. That's Deputy Gordon.
You raise your right hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, nothing but the truth, self you God?
I do.
You can lower your hand. State and spell your name for the record.
Lee Feely, F as in Frank, Eeley.
Good to see you again, Ms. Feely.
You as well.
Okay, just have a couple of brief questions. The other day, we questioned you a lot about Defense Exhibit 1, which was a purported phone call between Ms. Riley and the defendant, correct?
Yes.
I wanted to speak with you about your interactions with Mr. Dill's mother. Do you recall her ever turning over documents to you of alleged phone calls or communications between Miss Riley and Mr. Dill?
I don't remember myself getting documents, but I remember in the file there were documents like what you're talking about. And I do remember speaking with Mr. Dill's mother in the hallway at various court dates as well.
Okay, do you recall if she ever personally gave you those documents? It sounds like you're saying you don't remember how you got them, but maybe that they existed.
Yes, and it's possible that she did give me documents at one point in time.
And it's fine if you don't recall, but to your best recollection, these documents that she could have possibly given you, do you recall what they were?
I don't.
Okay, and you don't recall when this information was given to you?
It must have been at a court date if it happened, because I don't remember her ever coming to the office when I represent Mr. Dill. He did have prior counsel before me though.
Do you think that it was during trial, prior to trial? It sounds like it would have then been prior to trial.
It would have been prior to trial.
Do you know how far prior to trial? Was it more than 10 days? Was it?
It would have been
Judge,
more than 10 days.
Judge, I have an objection that this question has been asked and answered. She indicated she can't not remember when it was served on her, or even if it was the mother of Mr. Dill that served it.
Okay, I hear you. I'm going to let Ms. Eaglin go a little bit further because she's trying to pin down just some, yeah, it had to have been before trial. We got that because at first it was, I don't recall. And now we know it did not happen during trial if it did happen. So I'll let Ms. Eaglin go a little bit further, but I hear your point that Ms. Feely said, I don't remember exactly when it happened. Keep going, Ms. Eaglin.
Yes, I'm just trying to pin down when you did receive any information, just a roundabout time that it would have been received. Just to the best of your recollection. I don't want to make you have to speculate, but I do think the timing of when these documents were received would be important for purposes of the record.
Sure, and I'm not trying to be difficult. I just do not remember. I do remember interacting with Mr. Dill's mother at each of his court dates, so it would have been probably at a previous court date, probably a final plea, or I think he was on more than one trial calendar, probably.
Okay, do you recall if you had the opportunity to review any information that you would have received from Mr. Dill's mother?
I would have reviewed it, yes.
And do you recall intending to use any of that information during trial?
I don't remember it being part of our trial strategy or anything I discussed it with any detail with Mr. Dill, so no.
If the information you felt were helpful to Mr. Dill, would you have attempted to admit that evidence at
Yes.
trial?
Yes, ma'am.
Is it customary for you to do so?
Yes.
Is it safe to say in this case that if you did not, it was probably because you didn't find that information to be helpful?
Yes.
I know we briefly questioned you about defense exhibit number 1. Was this inclusive of the records that you may have received from Ms. Dill, Mr. Dill's mother?
I don't.
I want to make sure the record's clear. I think I understand your question, but were you asking Ms. Feely, hey, did defense exhibit number 1 come from Mr. Dill's mother?
Yes, Your Honor.
And I don't know. It did not come from my recollection to me from Ms. Dill's mother, but now having in hindsight and with all the discussion, it may have been turned over to prior counsel, and that's why it was in the file when I got it.
But your recollection, Ms. Feely, is that it was in the file. You simply don't know how it got there. It could have been from, I think the name is Mahone, but Mr. Dill's mom gave it to a colleague of yours, and that's how it ended up in the file. It also could have been in the file because it was part of discovery that the DA's office gave you, and then they couldn't find it in their own file when they cried foul.
Right. It was
Okay.
in what I physically got.
Got it.
Okay, I have no further questions, Your Honor.
Mr. Lewis, your witness.
The defense has no questions, Judge.
All right. I don't either. Ms. Eaglin covered all the areas I wanted to. Ms. Feely, thank you for your time. You're good to go. So everyone knows, I think we had signed off. Ms. Feely did resurface about 30 seconds after we shut down yesterday and people left. So she is findable. It's just she was in the middle of doing something else. Mr. Dill, I told you that I would let you know what's next when we wrapped up with the hearing, and we are, well, let me make sure. Ms. Eaglin, do you have any other witnesses you want to call?
No, Your Honor.
Any rebuttal, Mr. Lewis?
No, sir.
Excellent. Mr. Dill, here's where we are. I will take under advisement your attorney's briefing. So he filed the amended motion that set forth in much greater detail the concerns about errors in the trial. He has argued them in front of me with you present virtually or physically. The state has set forth its position on all that, and I need to enter an order. I will either grant your motion for new trial or deny it. If I grant it, it means what it says. You get a new trial in your murder case with one caveat. If I grant it, I promise you the state will appeal. Just like you get to appeal, the state will appeal. They'll go to the Supreme Court and say McBurney was wrong. If for some reason the Supreme Court decides this time to affirm me, then you'd get a new trial and we'd start all over again. I don't know if Mr. Lewis would be your lawyer for that. That's a conversation for you and Mr. Lewis. But you'd have the right to an attorney to represent you just like Ms. Feely did at your trial. It doesn't mean there'd be one. It may be you and the state work something out or who knows, but we'd start all over again. You'd get a new jury, all that kind of stuff. If I deny it, Mr. Lewis will file a notice of appeal. And then all the arguments he's made here, he'll have a chance to make in front of the Georgia Supreme Court. And he'll do that in writing, and then he may have a chance for oral argument. The main difference is you will not be directly involved. I'm sure Mr. Lewis will keep you in the loop, but you don't show up for court. There will not be a Zoom feed for you to watch. There are no witnesses for the oral argument in front of the Supreme Court. But if I deny it, there's still a whole nother level of appellate review. Any questions about any of that, Mr. Dill?
No, sir.
Okay. Ms. Eaglin, anything else on behalf of the state?
No, Your Honor.
Mr. Lewis?
No, sir.
All right. Thank you all for making yourselves available on short notice. We'll close out the record on the motion for new trial. I'll get to work on getting an order out. And Mr. Dill, we'll work on getting you returned.
Okay.
Thank you.
Thank you.
Thank you.
All right. Now we've got our calendar. I think as an add-on to the calendar, we also have a quick hearing in the Williams case. That doesn't involve any witnesses, it's lawyers.
Yes, Your Honor.
Because I try to get straight to something where we've got a witness, like we had, well, we had Ms. Feely as the witness. So I'm going to see how we're doing with the calendar, and we will certainly take care of the Williams hearing. And I think we had to add on with Mr. Powell. I think that's one of the cases Mr. Abate is here for. Mr. Cruz is here. And that's a bond hearing. Is that right?
Yes, sir. We have witnesses.
You have witnesses. Okay. All right. We will get to that. So let me find my list of who is where. And that is done now.
Yeah, tweet.
South Booth 2.
See his ass, man.
I should look.
Good afternoon, Judge.
Hey,
This is Francois here at ACDC. I do have 3 cases here at ACDC whenever you're ready.
great. We will turn to those in 1 second. There's one that I think we can handle real quickly if I can find it. Are you Mr. Davis?
Yes, sir.
Great. Ms. Rios, is Ms. Wood on, or is Ms. Primovic covering everything for Ms. Wood?
Ms. Primovic.
All right. Ms. Primovic, I'm gonna have you activate your camera just so Mr. Davis can see you, and we'll handle his situation.
Yes, Mr.
But none of you're on twice, but you're not, can you hear us, Ms. Primovic?
I can. I had to put you on my phone too because my laptop doesn't, you can't hear me from my laptop. So
Okay, there you are. Mr. Davis, I'm Judge McBurney, and your case has been assigned to me. Today was to be your arraignment day, but Ms. Wood, who is your lawyer who could not be here today, but who has as a colleague, Ms. Primovic, who you see on the screen right there. Ms. Wood filed a waiver of arraignment on your behalf, which means simply that she's entered a plea of not guilty. And she's also filed an entry of appearance, so she's officially in the books as your lawyer. The prosecutor on your case is here, and he will be getting discovery to Ms. Wood soon. And once she's got that, she'll be meeting with you. She may not be able to hand you all the discovery because there could be, for example, a CD with videos on it. You can't have that there, but all the paper discovery, police reports, witness statements, stuff like that, she'll get those things to you. I will see you again, either because Ms. Wood has filed a motion to suppress, a motion for bond, whatever motion she might think makes sense to file after she's met with you. Or if there are no motions, then I'll see you again after you and Ms. Wood have had a while to discuss, is this a case that's going to work out, or is it going to be a trial? Do you have any questions about anything I said or otherwise about your case?
I just wanted to know when my next court date. When I talk to
Say that last part again.
when my next court date, or when I'm supposed to see Miss.
Ms. Primovic, what's your sense as to when Ms. Wood might next connect with Mr. Davis?
she saw him on the 13th last week to tell him what to expect and to, get permission to file the waiver. Probably in a couple weeks.
Okay, so she's probably going to wait to get discovery, Mr. Davis, so that when she sees you next, she can say, look, I've read over the file. We've got a great case. They got the wrong person, or whatever it is. It's self-defense, or gosh, it's not a great case. There you are on video chopping this guy's head off with an axe, whatever the evidence might be. You guys will talk about that, and then Ms. Wood can talk to you about when your next court date might be. I'll see you again. If no one does anything, I'll see you again in a few months to have that conversation about, are we working this case out, or should we get a jury in here and get you a trial? But I might see you before then if Ms. Wood is filing motions on your behalf. That's a conversation for the two of you. Okay?
Yes, sir.
All right. Anything else?
No, sir. Could we go up for a bond hearing?
Say that again.
Do we go up for a bond hearing soon?
So there may be a bond hearing. You've already had a bond hearing. You may have had two. You would have had kind of one when you first got arrested. I'm looking your case up right now to see if you ever appeared in front of one of my colleagues before you were indicted, but this may have been one that got indicted pretty quickly.
Yes.
Yeah, it looks like it got indicted quickly enough that you didn't have that bond hearing. So that may be one of the things you and Ms. Wood talk about is in front of McBurney and have a bond hearing. That would be soon. We don't have to wait months and months for that. So where you need to be patient is let Ms. Wood get that discovery. She'll come see you, and then you two can talk about whether a bond hearing makes sense. Okay?
Yes, sir.
All right. You are free to leave the booth. Appreciate your time.
Okay. You have a blessed day, sir.
You too. All right. Let's do the AC/DC folks. I don't know who that is. So if you want to let me know who is there with you, we'll just jump in that order.
Thank you. Position number 13 is Britain.
All right. Hopefully it's not a complicated one. Let's see. 13. I got 12. Position 12 and 13.
Yeah.
Okay. Let me find my notes here. Ms. Rios, this is your case.
Yes, Your Honor.
All right, let me add you and Ms. Dilligard. I need to get that. Let me do one more thing. Did your camera come on?
Yes, Judge.
Isn't that exciting? No, I appreciate that. Let me add you to the screen. There we go. Now everyone can see everyone. All right, Ms. Rios, is this just to talk about setting aside the bench warrant? Is this also an arraignment, or what are we doing?
Yes, both.
Okay.
I filed the waivers in both cases, and yeah, I went to be heard on the motion to set aside the bench warrants.
Okay. Well, why don't we get on the record then? We'll get on the record in position 13, which is 24 SC 005457, State versus Troy Britton. And we are here talking about why someone missed court and what we ought to do now. So Ms. Rios, I'm ready to hear from you.
Yes, Your Honor. So she missed court in both cases. When she was locked up the first time, she became homeless and was kind of staying on friends and relatives' couches. So she didn't have an address at first. And then she said the last time she did update it when she was in the jail, but she didn't realize she actually had to go to the courthouse and update the address. And so they never had the correct address on file. And so she didn't know that she was missing court. And I believe one of the cases she believed was dismissed at the prelim, or someone told her it was dismissed at the prelim. And so that's why she missed court. She does have a stable address now. I filed a change of address in both cases. Her boyfriend has provided that to me. She'll be living with the uncle of her boyfriend when she gets released, and she's planning on, she was in Texas for a while, but she plans on to be here until she gets the case resolved, at least.
So the Fairmont Street address in Houston is, we're done with that for now.
Yes.
Okay. The other address that's popping up on the screen is Mandy Court in Jonesboro. Is that the one that you put in, or it's not in the system yet?
I just filed it today. Let me see if it was accepted, but I'm not sure if that was.
Got it. It probably hasn't made it through, but it looks like it's an address on MLK, but there's no apartment number. Ms. Britton, is there an apartment, or is it just a straight?
It's a home, Your Honor.
Oh, who's this?
This is Monty Griffin. She'll be living with me.
All right. Mr. Griffin, thank you for being here. So that address is, you said, is a house?
Yes, it is.
Okay. So the 1235, that will get mail to your place?
Yes, that's right.
Okay. And remind me or tell me your connection to Ms. Britton?
I'm an in-law.
Okay.
My nephew is, they're engaged.
Okay. Got it. Okay. So anything else, Ms. Rios, before I turn to Ms. Dilligard?
No, Your Honor.
All right. So Ms. Dilligard, you've heard an explanation. What are your thoughts about reinstating or setting aside the bench warrant?
Judge, the state will leave it in the court's discretion. Just want to notate that she did miss multiple court hearings. There was a court hearing back in May, then there was another court hearing in September, and then another court hearing in December, according to my notes. And so I just wanted to notate that for the court, but we'll leave it into the court's discretion.
Okay. Well, in one of the cases, the older one, at least by indictment number, the judicial hold order, so the bench warrant came when I guess we had it was in non-complex. Okay, so a different court. There was something, I don't have case management here. There was a case management hearing that was missed, and that got a bench warrant from there. And then in the more recent indictment, it was a plea and arraignment in December, and Ms. Britton didn't make it. So you're not saying, Ms. Rios, that Ms. Britton was in custody for either of those dates. It was that she had been in custody, and when she got out, she was unaware that the address in the system either wasn't the correct one, or I guess she didn't necessarily have a stable address.
Correct, Your Honor.
Okay. Ms. Britton, have you, how long have you known the young man whose uncle is Mr. Griffin?
Speak up, talk loud. I know things
I need you to get a little closer to the microphone because I can't hear you.
I know things about 2022.
I didn't hear that.
I was like, you said 2022?
Yes, ma'am.
Okay. All right. So Ms. Rios, you have waived arraignment in both cases and they can move forward now?
Yes, Your Honor.
All right. Let me see one more thing. How old are you, Ms. Britton?
I just turned 20.
How old is your client, Ms. Rios?
Oh, I'm sorry. She said she just turned 20.
Okay. And do you know who Jonathan Davis is to Ms. Britton?
I do not know.
Okay. All right. So what I'm going to do is I will reinstate the bond, but I'm going to add a condition that Ms. Britton have a county-funded ankle monitor. It has a 6-month duration. In other words, it will automatically come off after 6 months, except just before that 6-month mark, we'll all check in, and the state may have good reason to say, no, it should be more than 6 months. But absent an objection or my sua sponte decision to extend it, the ankle monitor would come off after 6 months. But the other conditions, for example, no contact with Jonathan Davis, whoever that may be, stay away from this address in College Park. Those conditions will remain in place. Let me make sure there are no other, that was for the 24 SC case. Let me make sure there's nothing in the 23 SC case. So I just found something I guess I need you to explain, Ms. Rios. I'm not trying to drag this out, but going back to something Ms. Dilligard pointed out, and looking at the case, the older case that was in non-complex, Ms. Britton had a bench warrant. It was set aside, and then she missed court again and got another bench warrant. Are you in a position?
I think that was a situation where she believed her address was updated and it was not the address it was supposed to be. And she said she let the jail staff know, but did not realize she had to actually come and update her address in the court. And that's how she missed court.
Meaning while she was in custody before the original bench warrant was set aside. So this would have been in August, late August of last year. She said, hey, my address is 1234. And she thought telling the jail would be sufficient. She gets out, notice is sent back to that bad address, maybe the one in Texas or who knows what, or the one in Jonesboro, and she doesn't get that notice.
I think it was the second time, from my understanding, it was the second time when she got a bench warrant, was released this, when she was released this last time, she told the jail her updated address, and then they never updated it, is my understanding. Is that correct?
That was on, I got released August 28th, and that was the case that they said that I thought that was dismissed, and I did give them my address, but I didn't get nothing from that, and I thought it was
Okay. We'll go with what I described. It's going to take a little while to get those bond orders modified, but I will do that. You will be fitted with an ankle monitor, and we'll make sure that the address reflects that address on MLK. Ms. Britton, it is super important that you keep Ms. Rios posted. If for some reason you need to move, you got to let Ms. Rios know. If you miss court again, I'm going to keep you in custody till we sort your cases out, because I'm giving you this second chance. It sounds like it's really a third chance based on the fact that a different judge at a different time set aside a bench warrant for you. So you've used up your I missed court. Okay. Do you understand that, Ms. Britton?
Yes, sir.
Do you have any questions about that? I don't want you to be confused about what I said.
What is a bond reduction?
I didn't understand what
I think she was confused about the bond modification. You said you were going to modify the bond. She's modifying the bond to add the ankle monitor condition and keeping all the other conditions. That's all he's saying.
So I gotta pay a bond, and
no, he's modifying the bond to add an ankle monitor. There's not going to be an additional payment.
Right. Your bonds that you had before are still your bonds. I'm just adding a condition that you wear an ankle monitor, but it's an ankle monitor that the county pays for.
So when do I have to go get the ankle monitor?
Well, I'm assuming it will get put on before you leave. I know that at the county jail, not at ACDC, the monitoring company comes there and they put it on you. You can't leave until it's on. Does it work that way at ACDC?
She'll actually get processed back to Wright Street, transported back over there, and they'll put the ankle monitor over there.
Excellent. Thank you.
You're welcome.
Okay. Ms. Rios, anything else on Ms. Britton's two cases?
No, Your Honor. Thank you.
Ms. Dilligard?
Nothing further, Judge.
All right. So we'll get a scheduling order out, which will trigger the state's obligation to, I want to see if the new waiver of arraignment form was used. Which triggers the state's obligation to provide discovery, assuming the defense circled the magic box or checked the magic box that says,
I did that before that.
Oh, okay. Dog. What? No, this February 20th. When did I do that new form?
I knew it there a while ago, so I did.
No, it's right there. It says defendant does opt into discovery. So there you go. Ms. Dilligard knows you've opted in and she'll send you discovery. Excellent. You didn't sign it, but we'll pretend you signed it. Okay. That's it. Who is next out at ACDC?
Position number 4, Rogers.
Oh, really? That'll solve it because we didn't know who the defense attorney was, but I bet Ms. Rios can stand in for that. Are you Mr. Rogers? All right, let me find your warrant and then we can sort that out. Rogers. Reed Hassan, there it is, Rogers. So yeah, I had 2 warrants. There was one from 21 and then one from 24, but it's the same case. And you have that the probation has expired? Well, boom. Okay. How long have you been in, Mr. Rogers?
4 months, 3 months.
Okay. Ms. Rios, me put this on you. I guess I'll ask Ms. Nelson. Someone should look to see if there's anything else holding Mr. Rogers in. I don't want to mislead him, but I will set aside the 2 warrants because his probation in the 14 SC case has expired. Oh, I did? You have something else holding you in jail? Do you know?
Yes, sir.
What else is keeping you in jail?
Well, when I went to court on January 31st, they told me I was currently off probation. That's why I took it on.
And the microphone is bad today at ACDC.
It looks like he has 3 other cases, and it looks like he already
I already took my time on it.
he already took a plea or something.
Yeah, I took my time on it because they told me I wasn't on probation for on January 31st. So I currently off probation, so I had to take the plea. I have 7 more months to do.
Okay, those may be why you're still in custody. I promise not to bother you again on this old case from 2014, because I've already signed an order, I guess, dismissing the warrants. It just didn't catch up to this calendar. But you're done with your probation in the 14 SC case. And whatever else you just described will be the reason why you're still in custody, but it won't be this case from 11 years ago, okay?
I'm not on probation.
Well, you are. Is he on probation in these other cases?
It won't start until you finish the
Okay, so the sentence he got was serve some time plus probation. Got it. So yeah, so Mr. Rogers, good question. You're going to be on probation on your new cases when you finish serving your time, but this old one that's been hanging around for a decade is now closed out. So you only got whatever your new stuff was that you just pled to is all that's left. I can't hear you. I'm sorry.
I have a release date on my cases.
Oh, do you have a release date?
Yes, sir.
For the current one?
Yeah.
As far as the information that we got from November 21st.
Okay, you think he'll go into GDC custody? Probably so.
I'm gonna say probably.
Yeah. So, Mr. Rogers, don't quote me on this because it's really the sheriff's decision. But if you were to serve maximum time, you get out in November of this year. So it may be you get transferred to what?
November or October?
Well, November.
Wait, do you know the date?
Department of Corrections.
Right. According to the Department of Corrections, if you serve the maximum time on your sentence, you get out in November and then you're on probation. I don't want to have a back and forth with you because 1, I'm not Department of Corrections. 2, they may have the numbers wrong and you can engage with them. I didn't sentence you in this other case. I don't even know what it's about.
So if I ask you this system here at the jail and say October this date?
I'm sorry, I can't hear you. I don't know what's bad with that.
No, I was saying if records created in the system here in the computer here and it says October 26th, that's the correct date.
So that's close. The date that is in the Department of Corrections is just like 2 weeks later than that. So I don't know which one is right, but that's I don't I don't know anything about your other case. I just have the good news that your old case is closed out.
Yes, sir.
All right. Sorry we bugged you today because you don't need to be held on this old warrant anymore. It's just the time you're serving on your new case, okay?
Yes, sir.
All right, thank you.
Position number 14, William.
All right, and then we're gonna buy you a new microphone.
Yes, definitely.
All right, Mr. Williams, let me find the notes that I've got on that. All right. Hey, Mr. Williams, can you hear me?
Yes, I can hear you.
All right. Your lawyer, Ms. Wood, who is not here today, but her colleague is, she's already waived arraignment for you. So she entered a plea of not guilty. That's it. She will be talking with you soon. My notes here say the bench warrant was set aside. I don't know why we did that, but
he was in DOC custody, Your Honor.
Oh, he was. Oh, that's right. We got documentation he couldn't make it to court. So why is Mr. Williams still in custody now?
I don't know.
Let's look. I don't know. It said it's got the bench warrant set aside, or the FTA set aside, and a PV warrant that expired from Judge Dunaway. So I'll tell you what, Mr. Williams, we are going to research this one to figure out why you're in jail. Do you have any clue as to why you're in jail right now? I don't know what you just said, but we will work on that.
I'll look into that too, Your Honor.
Okay. All right. Well, let me say this, Mr. Williams. Your lawyer will be getting discovery soon. So the paperwork in your case, she'll meet with you if you're still in custody. My guess is you're going to be out. I can't see something that's holding you in. Ms. Nelson, you are on this call. Do you see anything holding him in?
Judge, it looks like he needs a bond order on those charges.
Was he never arrested? I'll look into that.
Okay. Yeah, let me look.
It's got a 24 booking number.
No, he has I'm looking at the bond. So here's a bond. He's got a bunch of bond orders from pre-indictment. His final one signed by Judge Manning was a $68,000 good bond, and then an ankle monitor through the county. Stay away from some places. But you probably never got out, did you? But then did you go into DOC custody? Got it. Okay, so he's got a bond. You're just going to have to make that bond. So that's what Ms. Wood will talk to you about. If the bond is too high, she may want to have another bond hearing. But for now, there are no warrants holding you. You and your family or whomever are just going to put your heads together to see if you can make the bond in this case. Okay?
I got one question. I didn't want to know how much attorney waive my rights. I didn't even speak to it.
So she didn't waive any of your rights. What she did was waive your arraignment, which is a procedure where what I would have done was read into the record what your charges are: armed robbery, aggravated assault, told you the penalties and this and that. And then I would have asked you, Mr. Williams, do you plead guilty or not guilty to that? And I'm guessing you would have said, I plead not guilty. Because if you pled guilty, I'd have to sentence you to 10 or more years in prison with no possibility of parole. Ms. Wood entered the plea of not guilty for you, so that she can start getting discovery from the prosecutor. Okay? Now, you should express your concern to Ms. Wood when you see her, saying, hey, next time, don't file any paperwork without the two of us talking. And she'll let you know why she did what she did, and you may be satisfied with its answer and say, all right, no harm, no foul. Or you may say, this isn't working. You gotta be handling this differently. But that's an important conversation for you to have with Ms. Wood. I know she'll come visit you as soon as she gets her hands on that discovery, so she has something substantive to talk to you about, okay?
Okay, appreciate you.
All right, take care. So I think we're done at AC/DC, but I have a question for you, Deputy. Is the microphone always this bad? Because I'll put in a request to IT to get it fixed. This was terrible, and it didn't used to be this way. You guys used to be really loud.
Yeah, it's like this every day, Judge. I keep telling the clients, talk loud, but yeah, we have a really bad mic, so.
Okay. I'll let IT know. I think it's our court IT team that helps make all this work. So no promises, but it's going on a list of things they need to fix.
Thank you so much, Judge. Appreciate you.
One last thing before I let you go. Is this the one place that people connect from ACDC, or will they show up and they're going to go to a different place and say, no, look, the mic works on the 6th floor? Or is this always where things happen?
This is where it's at, Judge. This is where we
Okay, good. Then I'll let them know. Thank you so much.
Thank you, Judge. Have a good one. Be safe.
You too. Bye-bye. All right. Why don't we do the bond motion for Powell? That's where we've got some witnesses on. Is that correct? Okay. Let me see if I can find Mr. Powell. Yes,
Judge, while you do it, this case was indicted last week.
Oh.
And it's assigned to Judge Craig Schwall.
Oh.
25 SC 001137. Just want to bring that to your attention. I don't think it'd be something that Judge Schwall will handle, or you would go.
Well, I will get all that on the record, and I'll certainly let Mr. Powell know that, but I ought not to be deciding bond for a case that's been assigned. That's going to frustrate you, no doubt, but let's get everyone on the screen and talk about that. Most importantly, let me get your client. Salbutu.
And Honorable Judge McBurney, if I may ask, while you're in the process of getting Mr. Powell, we would love to have our bond hearing before you, Your Honor.
I'm sure you would, but you know how, I mean, it's not my case anymore. And it's not appropriate for me to be hearing something for another judge, but let me get your client on first. Are you Mr. Powell?
Yes, sir.
Great, Mr. Powell. Let me get you on the screen here. There you are. Let me get your lawyer on the screen. And
good afternoon, Mr. Powell.
Good afternoon.
Just sit tight for 1 sec. All right. Mr. Powell, I'm Judge McBurney. You have a pretty serious set of charges. Mr. Cruz, who has been advocating tirelessly for you and been trying to get you in front of me for a bond hearing, actually we were set down to have a bond hearing on December 17th. But either you hadn't had the prelim yet, or for whatever reason,
I wasn't counsel at that time.
you weren't on board yet.
I was not on.
Okay, so I'm curious, Mr. Powell, if you remember, and I don't know if you were brought out to court, why we deferred the bond hearing. It must have been your predecessor on the case, Mr. Cruz. Let's look. Whoever it was said, no, let's not do it quite yet. Let's do it in January or February. My guess is but then preliminary hearing was waived. Were you involved for the waiver of the prelim?
I was not. I would not have waived this preliminary hearing, but I spoke to him about it. I saw the docket on
I don't know whose signature that is.
I spoke to him about the waiver of the prelim and its effect, and circle around, Judge. We would love to have a bond hearing before you.
Got it. So here's where we are, Mr. Powell. You had a bond hearing date of December 17th, and whoever your lawyer was at the time, not Mr. Cruz, said, we would like to reset that. In other words, have it on another later day. I explained to that lawyer, and I don't want, were you sitting in court for this, or was I just talking to the lawyer?
I think you were just talking to the lawyer.
Have you and I ever talked about bond before?
No, sir.
Okay, then I was just talking to the lawyer. Did a lawyer come talk to you about it?
No, sir.
Okay, well, that's not how it should have worked. That's not Mr. Cruz's fault. It's also not the prosecutor's fault.
I remember, this was, remember your last calendar where people were being brought over without bond motions being filed because they had been booked into the jail. Remember that calendar where?
That's right, and the lawyers were saying, could we please have the prelim first?
Right, and they had never filed, a bond motion had never been filed.
Right.
So they weren't prepared for bond motion.
That's right. It was more an issue of, I'm not in a position to meaningfully argue it. I didn't ask for a bond hearing yet on behalf of my client.
Right.
So I suspect that it was a public defender, unless your family had retained someone, because you now have Mr. Cruz. In some ways, that's immaterial. I don't mean to minimize that you've been sitting in jail. Here's the material part. On February 21st, a grand jury heard evidence in your case and determined that there was probable cause to indict you for the murder of Dontavis Dion Ty for shooting him allegedly on November 24th of 2024. So you have now been indicted, and your case has been assigned to my colleague, Judge Schwall. It is his case, it's not mine, and I cannot hear bond in the same way I couldn't sit at trial or take the plea unless Judge Schwall were to say, McBurney, you can do this, and I were to say, and I'm interested in doing it, I got my own cases. But more importantly, Judge Schwall, has jurisdiction over the case. And he's the one who needs to hear from Mr. Cruz on your behalf, and maybe family members who could be on this call, hear from you. Importantly, hear from Mr. Abate and family members of Mr. Ty, who is deceased, about whether bond is appropriate in your case. So you should know, you can't see it quite as well because it's on a screen, but Mr. Cruz is looking at me with pleading eyes saying, Judge, we lined this up and we didn't know the case had been indicted. I am confident Mr. Abate didn't know until he typed in the PI number and said, whoops, I better let the judge know he is treading on thin ice because it's not his case anymore. Does this mean that you do not get a bond hearing? It does not mean that. It means that that bond hearing needs to be in front of Judge Schwall. And so I will make sure that my litigation manager, Ms. Nelson, reaches out to his litigation manager to say, Mr. Powell is now on your docket and he has teed up ready to go a motion for bond. Mr. Abate, who from your office would likely be handling this given that assignment?
I probably can go.
Okay.
I don't know if there's a lawyer assigned to Judge Schwall's courtroom at the moment.
Okay. That makes it simpler because we have sitting in this room right now the lawyer who'd need to be in a position to say, I'm ready to share the state's view on whether bond makes sense for Mr. Powell. But I can't go forward with this. I was looking at the calendar last night. Like, all right, we've got this add-on. We'll do Mr. Powell's bond hearing. I just didn't type in your case number, which would have flagged, there's now an indictment. This is going to seem like a real thin silver lining since you may have been ready to go with the bond hearing today. But because it's been indicted, now Mr. Cruz can start to get traction with give me discovery. He has the ability to say, you got to hand over this. Give me the police report. I want the body cam, whatever there is in the case. Until it was indicted, he only gets what the state decides it wants to give him, which is usually nothing. And so he's looking at the same warrant I'm looking at to see what's this case about. But he will be able to get that discovery. Actually will make it easier for him to make a more full-throated argument for bond because he'll have a better sense of what the case is about. And he can more realistically advise you, you know what, bond's probably not likely because the basics of the case are on live television. It shows you shooting this guy or whatever the facts are. So you're going to handle this in front of Judge Schwall. It'll probably be in person and not virtually like this. But that's where we are. Mr. Powell, do you have any questions about what I just described?
No, sir.
Okay. Mr. Cruz, I'm sorry that we kept you here so long. If we had taken this first, I would have known that. But I appreciate your professionalism surrounding this. I also very much understand your frustration. But you know where Judge Schwal professionally lives, 3 floors down. You in fact could go there straight off. I know he's not here today. He's working through something outside of the office, but his staff is here, and you could say, what's the first day I can get Mr. Powell in court for the bond hearing?
Yes, sir.
And the state's going to be ready. They were ready today. So they'll be ready, assuming Mr. Abate's not in trial somewhere.
I think we'll wait and then notice. You have the notice today. So.
And do you have just a quick question for you? I wanted to loop in an email with your staff assistant and the Honorable Judge Schwal's staff assistant, and just ask, because I think this would be his first bond hearing outside of his first appearance, if I'm not mistaken.
Oh, you're not mistaken, because his first bond hearing was going to be in front of me on December 17th, and his lawyer at the time said, we actually didn't file for bonds yet, not because they're lazy, but strategically they hadn't yet. They didn't know anything about the case, but they had automatically been put down because we were just grabbing every time there's a bond deferral. So at first appearance, he was not considered for bond because that magistrate is not allowed to consider bond with murder allegations. So he's never had a bond hearing.
So is that okay if I just loop him in and say, hey, we had a court date today before the Honorable?
You don't have to say honorable, but yes, Judge McBurney,
Very honorable.
and that's fine. Loop it in. You can copy Ms. Nelson. Everyone's going to back you up on this. Is that we were ready to go. State was ready to go.
Yes, sir.
We don't have jurisdiction over the case now. It is a Schwal matter.
Yes, sir.
Okay.
Well, that concludes my business, unfortunately.
You are excused, and Mr. Powell, I'm sorry we kept you in that little booth for no bond hearing, but Mr. Cruz, I suspect, is either going to go down in person right now to talk to Judge Schwal's people, or it sounds like he's going to shoot an email to their scheduler saying, could we schedule this for yesterday and get you in front of Judge Schwal for a bond hearing, okay?
Yes, sir.
And I'll be there to see you as well, Mr. Powell.
Thank you.
All right. All right, next up on the regular calendar is Alan Wade. And I think we've got Ms. Winfrey on. She was on. Yep, she's on. Let's find Mr. Wade, 4 South Booth 2.
Just one, leave these one. Judge Maddox,
Yes, sir. Was that, we had one, hold on 1 second. Let me just get, there's Mr. Are you Mr. Wade?
Yes, sir.
Great. You need me?
Can you do that?
Sinkfield?
Stokes.
Stokes. We'll do him right after this. He's up now?
Yes.
Okay, yeah, we'll do Stokes. I thought we have no other murders on here. We do. Alan Wilson. Okay. Do you need Mr. Abate? Ms. Rios, do you need Mr. Abate for our conversation with your client, Mr. Wilson?
No.
Okay, we'll have a prosecutor here, but it doesn't sound like Mr. Abate, this is on hold right now, while medical professionals work with Mr. Wilson.
Thank you.
All right, you're good to go.
Appreciate it.
You got a plea yesterday.
We did.
Huh?
The last minute.
Yep. All right.
Mr. Marks talked to his client. It worked.
Good job.
Have a good day.
You bet. Judge Emerson gets to be with his grandkids, so he was grateful.
I'm grateful. He's grateful.
Yeah. All right, let's turn to position 2, which is Mr. Wade. And I believe this is on, and let's get Ms. Winfrey on the screen as well. And hello, Ms. Winfrey.
Hello, Judge.
And Ms. Rios, so we can take this off. All right. So Ms. Rios is on for plea and arraignment, also a bond hearing. Have you already waived arraignment, or are you doing that orally and you'll file one? Let's knock that out first.
I think I filed it. I'm doubling checked. I'm pretty sure I filed a waiver on this case. Let's see, 527, and I don't think I found, and I don't believe this is a bond hearing.
Oh, okay. You filed a motion for bond and
Okay, I did. I think I realized he had, yeah, you're right, sorry.
on Valentine's.
I think we,
Okay. Can you hear me?
yes, and I remember why I did that, because there's several charges that he doesn't have a bond on. I think that was the issue. So the cases that he was indicted look like there's different and additional charges. So he had a bond, but it's not the right charges in the jail.
Okay. So if I look here, he has a whole lot of bond activity for Mr. Wade. And the most recent one was a bond that Judge Manning signed in September that had a whole bunch of conditions, but you're saying that there are counts in the indictment that are not covered by the September bond.
Yes, Your Honor.
Okay.
He doesn't have a bond on 4 counts. I'm not sure if I should read those out. It's in the, in the bond order.
Okay.
It's on my motion.
Got it. Ms. Winfrey, have you had a chance either to talk to Ms. Rios or ponder the state's position in light of the bond order that Judge Manning entered before the indictment?
So I have taken a look at that bond order that Judge Manning signed in September. I've not talked to Ms. Rios about it, but the state's position is that the bond amount remained the same, but it can be distributed throughout the counts that are currently indicted. So he's indicted on 14 counts. The bond order that was issued by Judge Manning covered more than 14 counts. Some were dismissed, but we are concerned that the bond amount, that it remains the same.
Okay. I don't have an issue with that. Let me see why there were so many bond orders here. Was it a situation where Judge Manning just kept lowering the bond amount, or?
Honestly, Judge, I don't know, because I wasn't involved in that part of this case. However, I think
yes.
It was, okay.
Yeah, I'm looking, your colleague, and I can't make out the signature, but an ADA consented because Mr. Wade had been in for over 90 days. And so the amount went down. It went down to $33,000 in June of 2024. Still hadn't been indicted. So there was a consent order for bond. That's what this one that I was describing. It doesn't say that on there. The entry in the docket says consent order. There's no signature from the state, but that just slashed the dollar amount more. So Ms. Rios, do you have any objection to keeping the dollar amount the same, but just making sure that every count in the indictment, which I hear you doesn't match up with what's in the bond, is covered by that dollar amount?
Yeah, no objection, Your Honor.
Okay.
And Your Honor, we'd also ask that the special conditions in that bond order also remain intact.
Oh, no question about that. I'm curious about the ankle monitor condition. Oh, now I see these charges. What's in the indictment? I'm surprised if that stayed in the indictment that the bond amount's this low. So in the end, it looks like, Ms. Winfrey, the indictment relates to computer usage and not direct physical contact with a minor.
Well, that's correct in on an overarching type of theme. However, this was an undercover case where the defendant was on his way to meet up with the alleged 9-year-old and 6-year-old.
Got it.
And
So,
he's, yeah.
so allegedly, had the arrangement worked out, then there would have been a little kid at the other end, but instead it was a big mean officer with handcuffs.
That's right, Your Honor. And the defendant's criminal history would necessarily require him not to be around kids.
Okay. Hence the ankle monitor. And I can't undo really what Judge Manning did. I guess it's just too long to indict, but okay. So your request then, Ms. Rios, is create a bond that spreads those dollar amounts across all counts. So there is a bond that can be made. You're not objecting to any of the special conditions. And Ms. Winfrey, I think quite understandably, is saying, please leave intact the special conditions.
Yes, sir.
Okay. Mr. Wade, you understand that do you work?
No.
When did you last work?
September of 2023.
Why did you stop working?
There was an incident at work and I was tricked into quitting.
Okay. What about getting a job somewhere else?
Well, after that incident, I was basically sick at home, sleeping 20 hours a day for 2 months.
Okay.
And I had just started recovering, and like you can look, I'm still not in really good shape. When I entered the jail, I had cellulitis and they were concerned about other issues. And I still can't close my left hand all the way. So there was just a whole bunch of things, but the big thing was I couldn't bring myself to get out of the apartment.
Okay. I appreciate you sharing that. That you shared more than you needed to, and I appreciate that. I'm looking up your address so we make sure we're on the same page about where you're going to be staying. The address I have is Chicago Street in Atlanta.
Yes, that I don't even know if that building's still there anymore. They were facing a numerous county, city enforcement things, and I had just received a notice of a mandatory meeting at the management office the day before I decided to go out on that meeting. And
where will you stay when you get out?
I have no idea.
Well, Ms. Rios, let's work on that before I do anything with the bond. If you would coordinate with Mr. Wade to see where an address might be, I'll be more comfortable messing with the bond.
I've already linked in Miss Ross. It's going to be problematic with his history of finding him housing.
Okay. Well, why don't we do this? I will put this down for an inquiry hearing 30 days out. We don't need to wait 30 days. If you and Ms. Ross are able to identify a housing opportunity, or Mr. Wade is through friends or family, and it could be that the Chicago street, where in Atlanta is that?
That's on the bluff. It's at the if you're familiar with the Make-A-Way housing program, it's across the street from there.
Got it. Okay. So Ms. Rios, we'll set this down for a inquiry about a month out to see if you've made progress, or Ms. Ross has, or Mr. Wade has, in terms of finding a stable address. We can consider other options. And as I said, if you all locate a place before then, we don't need to wait for that inquiry date. You can just shoot an email to Ms. Winfrey and Ms. Nelson saying, here's the address, and that'll give Ms. Winfrey an opportunity to say, hey, that's not okay. That's right next to a school or whatever. Okay?
Yes, sir.
All right. Ms. Winfrey, anything else on behalf of the state?
No, Your Honor, thank you.
All right. Mr. Wade, do you have any questions about what we discussed?
I have any questions with Ms. Rios.
Okay, well, she'll be in touch with you and you all can talk about that. So Ms. Rios, you did file a waiver. Ms. Winfrey, you'll be getting discovery to Ms. Rios if you haven't already?
It's been served, Judge.
Excellent. Okay, and then we'll get that scheduling order in place if it's not already in place, and that will move the case along. Thank you.
Thank you, Your Honor. That concludes my business with the court. May I be excused?
Yes, ma'am. And Mr. Wade, you are free to leave that booth.
Thank you.
No problem. All right. Uh-oh, no, Mr. Hassan. My notes are that Ms. Wood wants to reset this because Mr. Hassan has a whole bunch of new business to go along with and maybe is the basis for his revocation. Have you heard the same?
And he's on a plea arraignment for March 4th on one of his new cases.
Oh, and I think the new case, I think it's purely random. It got assigned to me.
Right, random. So
Okay.
he'll be back on 3-4.
All right, then let's not sweat it, Ms. Alexander, in terms of getting Mr. Hassan in the cell. I was told he'd be here, 4 South 3.
You sure you don't want me to call him?
I mean, if you can get him, I'm happy to share the news, but he'll also be here in court. Well, I don't know. What day did you say it was, Ms. Primovic?
It's March 4th on Odyssey.
Okay, then that's a Tuesday. So he'll be here in person in 4 business days. So I wouldn't worry about it, Ms. Alexander. We're good.
Yeah,
Yes, sir.
Ms. Wood saw him last week or so, and he's been informed.
Great, thank you. Oh, you wanted to do, let's do, I'm sorry, Mr. Stokes, who got brought over. And Ms. Primovic, do you know, we're going to handle Mr. Stokes. He's here in person. And the notes are that you all have a conflict for some reason. Is that, are you in a position to say what the conflict is?
Yeah, he's maybe a witness in the Chiquita Favors murder trial case that Lacey has.
Got it. Meaning Mr. Stokes may be.
Correct.
Okay, got it. Hey, Mr. Stokes.
What's up, Mr. McBurney?
It's been a minute. How you been?
I'm all right.
Good.
Been trying to be a law-abiding citizen.
Trying. Well, at least you're trying. We are not going to be able to do your revocation today. You allegedly picked up some new charges.
He got dismissed today.
Oh, today?
Today.
Good.
That's where
Okay.
it came from.
Well, that'll help your lawyer work through this, but the public defender, and you may have met with Ms. Wood, I'm not sure if she came to visit you, they got a conflict and cannot represent you because they represent someone else.
They represent my mom.
Who's your mom?
Chiquita Favors.
They represent your mom, so they can't represent you for this revocation. I'm going to get another lawyer appointed to represent you, and that'll move this forward. Is this the only thing holding you in? Yes. Are you familiar, Mr. Patrick, with the charges being dismissed?
I just checked Odyssey and there's nothing in there about them being dismissed. They're in the solicitor's office, Judge.
Oh, okay.
They are, I mean, they're essentially, they're probably being dismissed because I was intending to assert jurisdiction.
Oh, that they were heading your way. Okay. Well, you got a couple other issues as well. We've got not having knocked out a few of the things you committed to doing while you were on probation. But more importantly, we can't move your case forward today.
What I was finna say, I ain't doing that though.
Okay.
The charge that held me.
That's probably right. But don't talk about it without your lawyer here. So let me do what I need to do. And I think Ms. Primovic, per Ms. Wood, you all have already filed the paperwork that will basically pop this over to Ms. Cabrera or one of her colleagues.
That is correct, Your Honor.
Okay. So we'll get that lawyer working on your behalf, and she may be able, or he may be able to coordinate with the prosecutor and say, we're good. There doesn't need to be a hearing because of this dismissal or that. I don't think that's how it will play out. We'll probably need to see you again so we can have a conversation about what to do with this warrant. And I'll tell you, the most serious thing on there were the new charges. If the new charges go away, the other stuff are technical violations. They're not minor, but you got to get your GED. You got to do the family violence intervention program. But that's easy to work through.
When I was trying to get the family violence intervention thing, like I called like 4 different numbers. Nobody. I got it from my PO too. He'll tell you.
Okay, good. But I mean, that kind of, if your PO is verifying, no, wait, Stokes was trying to do this stuff. And like I said, those are the easy ones to work through. It's the new charges that are messier. And that's why you want to have a lawyer helping you with it. Okay. So I promise to get you back here as soon as we can line up that lawyer so he or she can be your advocate. All right.
All right.
All right. Be safe.
How long do you think they're going to be?
It's a good question. I don't know, but it's weeks, not months. Okay.
With that, Joe, my vote is complete. May I be dismissed?
Yes. Two things. One, how's it going with what's that case where you're going to make sure it works well next Tuesday?
I have found what I believe to be all of the cases, and they are supposed to be opened today.
Okay.
And
that's a start.
And I sat down yesterday to learn how to properly draft an accusation so that they can all be filed.
See how much we're training. You're only in this courtroom for like 6 days and we're giving you all the critical training.
Oh, yes, Judge. I mean, well, tongue in cheek, I mean, notwithstanding, that's true. I need to know how to accuse a case.
Yeah.
That's going to come up again.
It will.
And then Ms. Charles is actually, I believe she's in a trial. Her door is shut and says do not disturb act. No, she was number 2 out this week.
In some courtroom. Okay.
And so I haven't seen her, but I will.
All right.
Thank you, Judge.
You bet.
Well, you said there were 2 things. What was the other?
That was it.
Okay.
That was a long question, I guess. That's it. Oh, no. The other one was, so do we see you again before you go to other courtrooms?
I don't think so. I don't have anything on tomorrow.
Okay.
I don't think. I looked at it's a clean arraignment tomorrow.
Ms. Dilligard will let you know, because if it's yours, she's gonna spread the word. You don't need to worry. So then good luck if I'm not gonna see you again.
Well, thank you very much.
You bet.
I do. Oh, she told me she thinks I do have.
All right, see, you thought you were done. People get excited, not free.
Could you send me that?
2-2.
I have one that doesn't have all of. I looked through and I was like, I don't have anything on this. Yeah, if you'll just forward me.
This is next week.
Oh, that's next week.
Yeah.
Okay.
They're blurring together for her. She has so many calendars.
This is mine, so no.
Okay. All right, Judge, then I will see you around.
Farewell.
Thank you, Judge.
Mr. Sinkfield, can you hear me?
Good, yes, I hear you, Mr. Judge McBurney. How you doing?
I'm all right. Sorry to see you where you are. Ms. Rios, are you handling Mr. Sinkfield's case?
Yes, Your Honor.
All right, let me get you on the screen And let's add the prosecutor. Okay, we have half of, it adds up to 1. So Mr. Sinkfield, you are here. Let me find your warrant. Oh, it's this one with the stripe. You're here because of a probation warrant that I signed in August about departing from the residential treatment program that we identified, and maybe you didn't even show up while you were in drug court. So we need to work through next steps on that. Ms. Rios, have you had a chance to speak with Mr. Sinkfield about this?
Yes, so I emailed you he was accepted to PAD. I've also spoke with probation and they're fine revoking 60 days. We cannot with PAD though, they won't let it be a condition of it. But they have the letter and I've spoken to PAD and that's what they said. It can only be diversion or just being left off of the condition, and probation is aware. I've spoken with probation about the situation and we were all on the same page.
Okay, well, let's get this on the record then. Ms. Rivers, are you good?
Yes, Judge, I was on the record.
Great. So this is 22 SC 182-227, State versus Sinkfield. And we are here on a revocation hearing. Mr. Sinkfield, the allegation in the warrant is that you were terminated from drug court. And it sounds like Ms. Rios, Mr. Sinkfield is admitting to that allegation?
Yes, Your Honor.
All right. And tell me, Ms. Simpson, how much time remains in Mr. Sinkfield's case?
He had 1 year, 11 months remaining.
All right, just under 2 years remaining, Mr. Sinkfield, on probation here. Your recommendation, Ms. Rios, is to revoke 60 days, reinstate the balance, and hope he does PAD, because it doesn't sound like I can make it a condition.
Yes. And I've talked to him several times. He's been adamant about PAD since the beginning. I have full confidence that he's going to do what is required of PAD. They're going to find him housing. They're going to find him work. They're going to address his underlying issues. And we've spoken at this point, met in person twice and several times over the phone. He's spoken to Miss Ross. He's been very adamant that he's wanted PAD.
Okay. Mr. Sinkfield, is there anything you want to add?
I want PAD. I need my own place. I can't live with my mom no more, Mr. George McBurney. You already know. So
how is your mother doing?
She good. She good. She doing good. She happy now that I need to pay a program. That'll make her a whole lot happy. If I get
okay.
Yeah.
All right. Please.
Our recommendation to Ms. Rios was actually to revoke 60 days and suspend the balance because we couldn't make it a condition and we didn't want to keep him back on probation due to it's not a part of drug court, so he wouldn't be able to report.
When you say he's now part of drug court?
He's not.
He's not, that's correct.
Because he's not a part of drug court, he wouldn't be able to report if we put him back on probation.
Got it. So you're not objecting to the 60 days. Your point is suspend the balance so that PAD happens. You're not able to supervise because of PAD's philosophical approach to this. Okay. Ms. Dilligard, your thoughts about what we do with Mr. Sinkfield?
Judge, I have no objection to the agreement between Ms. Rios and probation. So we're comfortable with the 60 days suspending the balance.
Okay. I'm just looking up Mr. Sinkfield's case so I can see. So Ms. Rios, PAD is ready for Mr. Sinkfield now?
Yes, Your Honor.
Okay.
I spoke with them last week. So I don't know how it works as far as like them coming to get him, but I think I can call Mr. Material as soon as the order is in. Or I'll call him after we're done with court today and let him know to expect him.
Okay, right. It would be to expect him. Mr. Sinkfield's responsible for getting to Pad. Do you know where Pad is, Mr. Sinkfield?
No, but I think it's on Macon Drive. I can find it though. I'll give you information.
Okay. What's your thought about that, Ms. Rios? I'm a little less enthusiastic.
I will call. If you give me a second, I'll call and make sure I get the address and I can tell him.
Let's do that.
Okay.
Thank you.
So in theory, who we're doing next is Darius Reed, but I don't have a location for Mr. Reed. Ms. Alexander, do you know where he is?
Yes, sir. He's in Cobb.
He's our Cobb person. Got it. Thank you.
Judge?
Yes, ma'am.
I'm on the phone with Ms. Ross, and she was saying that she didn't give me the address, but you could just put on the probation revocation release to Pad.
And what does that mean? They'll come get him?
Yes.
Oh, okay. I'll work with Ms. Simpson as to how we do that. Okay.
I'm sorry?
I said, that's good to know. I will work with Ms. Simpson as to how we word that, because if I were to revoke 60 days, Mr. Sinkfield has already done 80 something days. And so he just, as soon as I sign the order and the jail gets it, they'll let him out. And that's not released to Pad, that's released to the street. So I may need to do, for example, revoke 3 months, reduce the time served upon release to Pad or something. But I'll talk with Ms. Simpson about how we need to word it so that there is that smooth handoff, which I think is important. And I appreciate Pad providing that service, because then Mr. Sinkfield is being released directly into the welcoming arms of Pad. We wish him Godspeed from there.
Okay.
All right.
Okay, and then I will,
You good with that, Ms. Dilligard?
Okay.
Yes, Judge.
Okay.
Thank you.
right.
And she said that she's going to confirm the date and then email the release order. That's how we do it, I guess.
She's going to do what?
She's going to send me the release order for Pad. Ms. Ross. And I'll send it to you.
Okay.
I'm a little confused how this works either, but I'll just go with that.
Okay. I just want to, the more we can ensure that Mr. Sinkfield is released to Pad rather than to Rice Street, and literally the street, the better. But I'll work with Ms. Simpson on that, and with you, you'll just get us what Pat sends you.
Okay, thank you.
All right, thanks. Mr. Sinkfield, do you have any questions, Mr. Sinkfield? All right, good luck.
Thank you.
All right, bye-bye.
All right.
Hey, Mr. Reed, can you get the speaker on? Oh, there's our friend.
How you doing, Judge McBurney?
I'm doing all right. Let me get a lawyer on there for you. So, Mr. Reed, let me find my notes for you. We have, I'll hold on to Mr. Sinkfield. Hold on one second. All right, I have your warrants here. And Ms. Primovic, you're prepared to go forward with Mr. Reed's revocation?
Yes, I am, Your Honor.
All right, let's get on the record. We've got Darius Reed. He's 22 SC 185093 and 23 SC 186074. We got a burglary case and an aggravated assault case. Ms. Simpson, how much time is left on the 093 case?
3 years, 8 months, 11 days.
All right, and on the 074 case?
3 years, 2 months, 6 days.
All right, you got a little more than 3 years on one, a little less than 3 years on the other, Mr. Reed. And the warrants that I signed in August of last year allege that you violated the law in July of last year for getting arrested in Fulton County for looks like a drug charge and then a little bit of marijuana. You also hadn't completed either your family violence intervention program or started to obtain your GED. Ms. Primovic, is Mr. Reed admitting to these allegations, or at least stipulating to the arrest and admitting to the others?
Yes, Your Honor. He went down the road on the new charge and where he got his GED, but probation does not have a certificate of that. So his fiance is trying to get probation that certificate. He only did 2 classes of the family violence, but we are stipulating that he did have the new charge and that the probation does not have proof that he completed his GED. So we are stipulating, Your Honor.
Okay, but what you're saying is that Mr. Reed completed his GED while he was in custody for these new charges?
Correct.
Wow, that was quick.
He went down the road in fall of 2023. He was released. He got arrested for the drugs in July. He's been in custody since December of 2024 for this BOP judge. So
Okay.
it's the only thing holding him in.
Okay. What is your request?
We're asking for 60 days, Your Honor, and reinstate the probation. He has a verifiable address. Probation should have it. If not, I have it for him. He can return to work at 2 men in a truck. So he has a job. He has a secure home. He has an involved fiance who's very concerned about him and keeps Miss Wood updated with addresses and his job and the like. So we're asking for 60 days, Your Honor.
Okay.
Probation.
The one thing I'm confused about is that you said based on the charges, what would be the new charges, he already pled and went to prison. Maybe there's a typo in the warrant, but what the warrant says is that he was arrested in July of last year.
I was mistaken, Your Honor. He got his GED on the charge that he's on probation for, the 18607-4.
Okay.
I misspoke, Your Honor. He
That's
got arrested
okay.
for the charge in July, and that's, I think it's still open, the marijuana charge.
Okay. So that's a pending case, but that whatever sentence that he received, Mr. Reed received in the case ending in 074, you said he had custody.
Yes, he went into DOC.
Okay, let me look at that. Oh yeah, look at that. 5 to serve 1. Okay. All right. Mr. Reed, is there anything you want to add?
Yeah, I did receive my GED, and I did enter the reintervention program. I believe the one last other stipulation I had was entering the psych eval, and that's the only one that I commit that I didn't, commit to, because I didn't know if they was gonna make me a dependent on opioids, Judge McBurney, and I'm not a drug addict, and I just didn't want to become an addict. But all my other stipulations I have completed, or the GED I completed, and I can show proof of that, and the classes I am taking. So I am taking the initiatives, to stay out of trouble and just keep my head low.
Got it. Okay, I'm hearing you, and it's easy enough to prove up the GED part, and it sounds like your fiance is trying to get that. Is that who Ms. Wilson is? Who's the Ms. Wilson you were talking about?
In regards to, no, Ms. Wood.
Ms. Wood, okay.
Yeah, she had emailed me about the GED.
Okay.
And stated that she was forwarding that certificate to his supervising officer.
Oh, meaning Ms. Wood was getting it to, okay, not to you directly, but to Tobias Todd?
Yes.
Okay, got it. That's helpful. All right, so it sounds like, Mr. Reed, that Ms. Wood, who is Ms. Primitic's colleague and your main attorney, she did get from you or your fiance that GED proof and was sending it to Officer Todd.
Yes, sir.
All right. What's the name of your fiance?
Stasha Clark.
My name is Stacy. I'm here.
Gosh, that's a different name. Are we talking about different people?
Same person. On the Zoom call, it's Stacy, so you'll know where to look.
There you are. Okay, Stacy. I'm gonna call you Ms. Clark. Did you provide to Ms. Wood the paperwork about Mr. Reed's GED?
Yes, I provided that to Ms. Wood and also the probation officer.
Okay, how did you get it?
I received it from his mom.
Okay, any idea?
When he came back home, he had the certificate. So I took a picture of the certificate and gave it to Miss Wood, and then she also gave me Mr. Todd's information. I emailed it and I texted to him also.
Got it. Okay. So one of the conditions of Mr. Reed's sentence is to have no violent contact with you. Has he been doing well with that?
Yes, we haven't had any violent contact.
Okay. How long have you been his fiance?
A year and a half.
Is he ever going to make it official, or is he just talk?
He's a lot of talk, Judge, but we'll talk about that at another time.
I bet that's between the two of you. I don't need to be in the middle of that. But if you need a free officiant, I can help. I can do the wedding for free.
I would appreciate that.
All right. Let me turn to Ms. Dilligard, because we do need to work through the serious process of what are we going to do as a result of some of these hiccups. It sounds like the GED piece is much less of a hiccup, and the family violence intervention he can plug back into. There are the new charges that are still pending out there. Mr. Reed has been sitting in the jail for 58 days. That's why I get the magic 60. Tell me your thoughts, Ms. Dilligard, and you may be pinch hitting for Mr. Patrick because he ran out of here and it's got his name on it, but bet you can do it.
Yep, I can handle it, Judge. I think after speaking with probation, their recommendation is to revoke a year based off the drug charge. And so that would be the stance of the state. However, we'll leave it in the court's discretion, but we are asking for no less than 180 days.
Okay. Mr. Reed, how long have you worked at the 2 men in a truck?
Going on 5 years, Your Honor, and as soon as I can get released, I actually want to start going to school to get my CDLs. I'm just ready to get this thing behind me so I can start that, Your Honor.
So you can be driving the truck rather than riding on it?
Yes, sir. And
okay.
So my DOT, I just didn't receive the actual CDL license yet, and that's what I'm going to pursue. Like I say, I've been staying out of trouble, keeping my head low, man. Just trying to do better, Judge McBurney. That's it.
Oh, okay. Well, I'm hearing that, but then you picked up these charges in July, so that's not quite staying out of trouble.
Well, Judge, I will say for one of those charges, he was driving my vehicle. I understand, the law, however that works, but that wasn't on him. It was in the vehicle from a vacation. So that wasn't, he was in the vehicle, but that wasn't.
Okay, well, you probably want to not say too much about that because the prosecutor's eyes got real big when they heard, wait, what? This is this lady's drugs? So, and as you just said, you know what the law is. If the driver has stuff in the car, the default is that's probably the driver's stuff, unless it's in your pocket or something. But I really don't want to dive into that. I just wanted to see where the case was, and I think I found it. So it remains unindicted, and it's 3 counts. It was speeding, a little bit of marijuana, and then some Schedule 1 or Schedule 2 drug. Let me read one thing more, and then if there's anything Ms. Primovic wants to add, as opposed to your unofficial lawyer, Ms. Clark, let's see. So it was Roswell, 400 northbound, a blue Hyundai. Ooh, going 90, Mr. Reed. That's not keeping your head down.
I was late to work.
I didn't know a Hyundai could go that fast.
I was trying to make it to work, Judge McBurney.
Yeah, I'm hearing you. This was going to work as 2 men in a truck?
Yes, sir. Yes, sir.
Okay.
Yes, sir.
All right.
I have a 1.5-year-old, Your Honor. Like I say, man, I'm just ready to get this behind me so I can get back to being a family guy and, just doing good. I my fault.
Okay. Man, this thing was a rolling cannabis car.
It was actually a vape pen, Your Honor.
Yeah. Peanut canna butter cookies. Never heard of those. All right. Got it. So here's what I'm going to do, Mr. Reed. I do think your heart's in the right place. You don't always have your brain in the right place. But I am going to revoke 6 months of your probation. You'll get credit for all the time. I'm going to revoke. Oh, Ms. Wood's not on a call. Ms. Rios. And you may know, Ms. Primovic, what's the amount of time that is that threshold between Department of Corrections versus?
We don't
I
know
thought
it
it
yet.
was-
And if he, go ahead.
I don't want to say because I'm not 100% sure.
I'm actually pretty sure now that I say this. Here's what I'm going to do. Am I able in the revocation order to say no credit for time served? Okay.
Well, Judge, if he goes into the DOC, he will not get credit for time served. But if
This
he
I
stays
understand.
on-
Nope,
Okay.
that I understand, and I don't want that to be how this plays out. So I'm going to revoke 4 months of probation. but not give you any credit for the time you served. That will keep you local, and not send you down to the Department of Corrections, but will result in a 6-month consequence for you not using your brain in the way you should if you got a 1.5-year-old and this lady you've been stringing along promising you marry her for 1.5 years now. So once you've knocked that out, I will suspend the balance of your probation in the 23 SC 186074 case and reinstate the balance, that's the shorter balance, in the 22 SC 185093. So you will remain on probation in one case. The other balance is suspended, so that's effectively closed out. And that means you just got to walk the straight and narrow for a slightly shorter time, about 4 months shorter. And we will take it from there. Ms. Primovic, anything else on behalf of Mr. Reed?
No, Your Honor. He'll be given notice on where and when to report.
We're going to hear from Ms. Simpson on that before we break. Ms. Dilligard, anything else from the state?
Nothing further, Judge. Thank you.
Okay. Ms. Simpson is going to go to the microphone so you can hear her, Mr. Reed, about your reporting instructions.
All right.
Mr. Reed.
Yes, ma'am.
Just make sure you are reporting to your officer, Officer Todd, within 48 hours of your release. I have your updated address. I received that from Ms. Wood, so you're good on that part. Just make sure you report within 48 hours to Officer Todd.
Yes, ma'am.
Do you have a phone number for Officer Todd?
Yes, I do. I try to call him frequently. It's a lot of times he's either busy or he's just not answering. And when I call the center, they tell me all the time if he's not answering, just leave a voicemail and call back.
Okay, and that's all you need to do. If you're leaving voicemails on his phone, you've done what you need to do. So when you are out and about, one of the first calls you make is to him saying, I'm out, tell me the plan. And he'll either tell you where to meet him or say, report to the main office or whatever. So you're doing what you need to do if you're calling him.
Yes, sir.
But once you get out, if you cannot get him on the phone, just report to the Atlanta office and just say, hey, I'm here to report so I don't get violated. And they'll instruct you where to go from there. Just let them know who your officer is and they'll take it from there.
Yes, ma'am.
All right, that's it. Thank you.
Your Judge McBurney?
Yeah.
So, last question. I just want to know how long am I sentenced now? How long do I have to wait?
So I revoked 4 months of your probation without giving you credit for time served, because what I wanted to do, I think the reasonable answer is a 6-month revocation, given what happened. And if I revoke 6 months, you run the risk of having to go to the Department of Corrections. And that complicates you. You wouldn't get credit for time served, all that. So instead, I'm revoking 4 months, and you'll stay local, and we'll see how that plays out. So the most you would be serving would be 4 months from today. So you're out before the anniversary of you driving 90 miles an hour on 400 northbound with marijuana peanut butter cookies in your car. Okay?
Yes, sir.
All right. Any other questions?
No, that's it.
All right. Ms. Primovic, thank you for stepping in for Ms. Wood.
You're welcome, Your Honor.
All right. To South Boot 2. Mr. Jones is supposed to be reset, but he may have been asked to get into his booth. So I'm gonna see if someone's there. He is, he's there. All right, let me turn on the microphone, Mr. Jones. Hold on. Hey, Mr. Jones, can you hear me?
Yes, sir.
Great. Let's make sure we've got the right people on this discussion. So you, Mr. Jones, were on for a revocation hearing according to the warrant. Oh, we couldn't find you. And Ms. Wood, your lawyer, is working with her social services team to find a place for you to stay. And so Ms. Wood asked for a few more days to figure out a place for you to stay so that when she's advocating for you, she can say, no, we got a place for Mr. Jones. That may make the state more comfortable in terms of what they're going to recommend. It'll certainly make me more comfortable that we're not just releasing you to the street. So that means we got to reset this and give that team time to find something. Is that news to you, or have you already heard this is what we were going to do?
Well, actually, Ms. Ross came to see me, and Pat came and saw me, and they already approved it. I don't know. She told me she probably wasn't going to be in today, and that was going to be the reason why I was going to be reset. But they already came and seen me on last week, and I got approved for that. But she didn't tell me, that I was going to be reset on this. She said she would have someone sitting in for me, for her, and that would be the case.
Okay, and she does. On your screen, you'll see Ms. Primovic. That is Ms. Wood's supervisor, in fact, and is filling in for Ms. Wood. And it sounds like we're really all saying the same thing. It's great that Ms. Ross saw you because she's the social services coordinator.
Right.
And PAD may be one of the solutions that the public defender's office is going to recommend. But unless Ms. Primovic has heard something different, it's not completely buttoned up yet from their side. And so we were going to get you and Ms. Wood, who will be back, and then the prosecutor, Ms. Dilligard, together in a few days to be talking about what to do in your case. Okay. Ms. Primovic, am I summarizing that correctly, or is there late breaking news that Ms. Wood didn't have?
Yeah, you are correct, Your Honor. Unfortunately, we don't have any new news.
Okay. So Mr. Jones, that whole team continues to work on your behalf. They just haven't ironed out all the details of where your supportive housing would be. And so we're going to set this back down so that when we meet again, Ms. Wood can say, here's what we're doing. Okay?
I appreciate it, Judge, and thank you for your time, and I'll be looking forward to getting in. Do you know what time and frame? It might be next month, or it might be next week, or how does that work?
It's a great question, and you're welcome for my time, but I've been asked to set it out a few weeks. If something gets lined up sooner, then we can get you on an earlier calendar, either a Zoom one like this, or if we've got space on the bus, get you brought over here. So no one's interested in dragging this out. But what I don't want to do is say, hey, let's meet next Monday. And then Ms. Wood said, I'm not done yet. I told you I need a few days. Okay.
All right. I totally understand that. Well, thank you, sir.
All right. You take care. We'll see you soon.
All right.
Did you want to add anything to that? I didn't ask you. You're good?
No, yeah.
Okay.
Thank you.
All right. I promise we're going to get to Mr. Williams's case, but we've got to get through this calendar first. Let's see. I don't have that Mr. Wilson is in any booth. Ms. Rios, do you know if he was going to be joining us?
I thought so. I know Ms. Nelson said she did not tell him not to come over.
Okay. Well, let me ask, Ms. Alexander, do you have Mr. Alan Wilson in any booth?
No, sir. I received the email that he was supposed to be removed from the calendar.
Okay. All right. And my understanding, Ms. Rios, is that a doctor needs to talk to him again?
Yes.
Oh, right. It's a little more complicated than that. And if you need my help getting in the mix, I'm
not sure. So I spoke to Dr. Norman. I spoke to him yesterday. and he just needs he couldn't get a full understanding of what's going on. So he's going to schedule to come back on March 11th in the morning to talk to him. He said he's perplexed by some things that he needs just to have another chance to figure out.
Okay.
And so he was saying that it should be good to have him anytime after March 11th to put him back on the calendar.
On our calendar.
Yeah, on our calendar. I was hoping he was brought over just because I'm sure he's a little antsy of why he, so he could at least be here to explain a little bit.
Yep.
To him. But I guess we'll just put him back soon after March 11th.
Okay. One of the notes I received was that the setting for Dr. Norman or whoever it was meeting with your client, there are always deputies around and that made it more complicated. Was that Dr. Norman telling you that or?
Yes.
Okay. Is there a way to have a different setting or is that something Dr. Norman will talk?
That's what he's trying to figure out. I know the deputies were just basically not agreeing to letting him be out. And like he said, he usually goes to see them in the library and stuff, but they wouldn't leave his side. So I guess he's going to have to say, you got to let him, I have to see how he is going to be, I guess.
Yep. All right.
Not really sure.
Well, if that becomes a problem again, let me know, and then I can engage with the jail staff to see. There may be a reason why we have to do that. I always defer to them in terms of the safety of people there, but maybe if we ask nicely, it could be structured differently.
Yes, Your Honor. Should I email him and ask if he needs your help?
Well, if he didn't say he sees an issue, then I want to get in the middle, but you could flag it for him that if he is concerned about the format of their encounter, I'm happy to engage.
Okay, thank you.
Mm-hmm. We did Mr. Williams. Mr. Jordan.
He was in Union City. Was he brought over?
I don't have maybe he is, there is one South Annex. Let's see. They've been so quiet. There he is.
Yes, sir.
Hey, are you Mr. Jordan?
Yes, sir.
Their microphone works a lot better than AC/DC's. Ms. Rios, your case?
Yes, Your Honor. We have a pending ex parte situation.
Okay. So we're not going to work through the bench warrant situation. First, it would be get Mr. Jordan to talk with the doctor.
Yes, Your Honor.
Okay. Have I signed everything that needs?
I talked to the doctor yesterday.
Oh, excellent. Okay. Someone came to see you, Mr. Jordan?
She said I'm improved to be able to be doing whatever y'all said y'all gonna do for me.
Okay. How long did you talk to a doctor?
I don't know how long it was, but I know I talked to her yesterday.
Okay. All right. That's good news. That means that we'll get paperwork from that doctor soon, Mr. Jordan, and then we'll get back together.
My bad, Your Honor. She said it was gonna take like 2 weeks to bring it back or something.
Yep. She writes a pretty long paper about you, and it usually takes about 2 weeks. That'll go to Ms. Rios. You can see her on the screen there, your lawyer. It also goes to me. That's it. We're the only two who get it. And Ms. Rios and I will talk about it, and then Ms. Rios will come talk to you, okay?
So I won't get time served?
I don't know about that. That's a conversation for Ms. Rios to have with the prosecutor. We got to get that document, that report from the doctor first, okay?
Yeah, because I've been here over 40 days, and I ain't been able to,
We'll talk about it, Mr. Jordan.
All right.
Okay. I'll come back out. We'll talk.
I will see you soon, Mr. Jordan, okay?
All right.
All right. Thank you,
I see you, I'll be able to go.
That's what Ms. Rios is going to talk to you about, okay?
When would that be?
I'm not sure, but it'll be in the next couple of weeks, okay?
All right.
I just saw you last week, but we're going to talk about it.
All right.
All right, thank you, South Annex.
All right, you guys have a great one. Hold on.
All right. I think that is everyone on the calendar, the regular calendar, which gets us to Mr. Williams. And I don't know where he is either. Ms. Alexander, did Mr. Williams get pulled?
1 second, Judge.
Thank you.
What's his first? Is it position 14?
He was a separate calendar. Ms. Nelson had reached out through the regular channels to get him added. I can give you his booking number if that helps.
Let me see. Chuckle. Yeah, let me get his booking number real quick. I don't have it.
Okay, 2404-847.
Okay, give me 1 second. Let me see what.
Thank you.
Judge, I think that's all I have. May I be excused?
Yes, it is, Ms. Rios. Thank you. That is all you have. I will see you, I guess, tomorrow.
Yeah.
All right.
Bye.
Bye.
Judge, would you be needing me for this one?
No, ma'am. You're good also. Long day.
Yes, it is. I'll see you tomorrow.
Great.
Okay, he's on 7 South. I'm about to call the tower to have him pulled.
Thank you so much.
No worries.
Ms. Primovic, are you handling this?
Yes, sir, I am.
All right. Well, why don't we have an unofficial, off the record discussion before Mr. Williams gets here. So as I understand the issue, there is a witness for the state, a doctor who may have been the primary treating physician for the alleged victim in your case in chief?
Yes, Your Honor. He was the doctor who performed the sexual assault exam, sealed the kit, did all that on my primary victim.
Okay. And he is a traveling physician, meaning he's not linked to Grady anymore. He may be on vacation. Whatever the real deal is, he is not going to be he doesn't plan to be in Georgia next week.
He is working out of the country. So right now he's working in New York, and then he'll be back this Friday, and then leaves, I believe, Sunday to go to the British Virgin Islands to work.
Allegedly work?
Yes, Your Honor.
Okay. People get sick in the Virgin Islands. Okay. So he will be absent some forceful intervention by the state. He will be not able to appear in court.
Correct, for the date for next week.
Okay. And I know you indicated in your email, and Ms. Wood was copied on the email, hey, we could do this other week, but next week will be more difficult. And I believe Ms. Wood has informally, and she may have formally now, but it was enough to say, look, I object. That's not a witness that we're comfortable handling virtually.
Yes, and I know she had previously agreed in the hearing. That's why I reached out beforehand.
Okay.
I know trial is different than a hearing.
It is, and Mr. Williams is looking at more than 10 minutes in jail.
Yes.
So I understand both sides. And either one of you can answer this, Ms. Primovic or Ms. Reimer, and we'll get all this on when Mr. Williams joins us. I need to understand the impact if he's unable to testify. Is the defense going to say there's no good chain of custody and so you can't test the rape kit? Or is it simply going to be, I say simply, I don't mean to suggest it is without impact to the state's case, but you wouldn't have the medical professional who would say there was tearing and bruising and she had a gash in her side, although there might be a sane nurse who could help with that. Where do we fall, both in terms of chain of custody and the presentation of the state's case?
Your Honor, I'm speaking with the doctor, and he did everything. So he did the exam, He took the swabs, he put everything in the kit. There was a nurse there to assist, but in 2014 at Grady, it was not like it is now at Grady where there's a SANE at all times. He did everything, he sealed the kit, he signed everything. So I will have a chain of custody issue, and I will have an issue with testifying to her actual sexual assault exam.
Do you have the nurse who was present for this happening?
Right now, ish, she has been subpoenaed. We are working with it, but my plan is to have her.
Yeah.
And again, it's been an issue because no one's at Grady anymore. It was 2014.
Okay.
So at this moment, I need the doctor.
Because you don't have the nurse, and two, you don't know if the nurse is going to be able to say anything other than, hey, the report says I was there. I remember nothing about this.
Right. And even based off the notes in the medical records, the doctor did everything.
Okay. Ms. Primovic, pivoting to the defense. So this seems like a central witness on two fronts. One would be to describe the results of the medical exam, et cetera. But two, in terms of chain of custody, if he is the originator of the swabs and signed the kit, et cetera, I'm curious if I say no continuance, but the price of not continuing, because Mr. Williams has been in jail for a long time, and we've already continued it at least once at the state's request, you'd need to waive a chain of custody challenge. So in other words, there wouldn't be, the jury wouldn't hear about all the graphic detail of the physical exam, but there wouldn't be a challenge to chain of custody.
Yeah, we would.
I don't know if that was clear. I want to be clear. First of all,
we would not waive that step.
Okay.
On chain of custody.
Okay, and in saying that, that's either with consultation with Mr. Williams, where he said, I don't mind waiting in jail for another month to get this doctor back here.
He does not want this doctor on Zoom. This is an important doctor. This is really their biggest witness next to the complaining witness. And Mr. Williams and I have met privately and have met together with Ms. Wood. And this is not something that he wants to have over Zoom in front of a jury.
Okay, and that I respect, and that's his absolute right, and there's not a workaround for the state on that one. I didn't ask my question well. I don't think you need to say, oh, that's fine, we'll just have him appear virtually. If he does not appear at all, because you would be objecting with good cause to a virtual appearance. If he does not appear at all, to me, the reason why I would grant a continuance would be on the chain of custody front, not on the other parts of, well, we don't have someone to describe what the results of the exam were. And so one way to skin this cat and get Mr. Williams a trial sooner, because he's been in jail for a very long time, would be a stipulation as to chain of custody, not anything else to which he'd testify. Because frankly, if the only thing he was a chain of custody witness, let's say he was the officer who collected the shell casing and put it in an envelope and sent it away, I'd be surprised and frustrated, but that's all I could do if the defense said that person cannot appear virtually. Because that person is simply saying, I picked up a shell casing and put it in a bag. And in one small respect, that is the role of the doctor. I took these swabs, put them in a bag, and sent them off. That chain of custody piece, I will continue the case if people are not going to stipulate as to chain of custody. I'm not saying the defense needs to stipulate to a reading of the narrative in the medical records, et cetera, all that kind of stuff, where I could see where a face-to-face cross-examining, what did the victim say to you, and this and that. That's where the confrontation rights seem to me to be most robust. But on the kind of mechanical, I took these swabs, I put them in the bag, that's my signature. That to me seems, I don't see the pressing need for face-to-face confrontation of the doctor on that one piece.
I understand where you're coming from, Your Honor. And Mr. Williams, we are not going to stipulate to any part of the chain of custody.
Okay. Got it. And you don't need to. I just wasn't sure if it had been refined to that level. I don't have the medical.
sorry to interrupt. We've discussed a lot of things with Mr. Williams.
Okay. And I'm grateful that you and Mr. Williams are having dialogue, and I don't want
to
upset that. We seem to continue to have witnesses who can't be here when it's trial.
Well, Your Honor, we are good for your normal division calendar. For the 13th, I understand we are on the consolidated calendar. I have no issues with the next calendar.
Right now you don't?
Yes, I do, Your Honor.
Okay.
And again, it's not an excuse, but I came back into this from maternity leave, and I was trying to get everything to go. Because this doctor was a mobile doctor, we were not able to get him, so we were sitting on him. And this is when I first found it out. Had I known before, I would have brought it to the court's attention before.
Okay, I'm not faulting your time frame. I'm just
I'm not happy about it either.
no, this was a great case for Judge Emerson and not for me. But it needs to be tried, and so I'll have to look at the March calendar and see what else is on it. And unfortunately, I don't have something else to put on the Emerson calendar. I would love to say, great, then you need to be ready on State versus Smith, but you and I don't have a State versus Smith, and I can't turn to Ms. Dilligard and say, go try this other, because there's nothing else. I only have one other case on the Emerson calendar, and it can't go either. He's got other cases to try. It just, I miss out.
I understand. I do apologize.
No, this is not an apology situation, and I'm not frustrated with Ms. Primovic and saying this isn't something we're going to stipulate to. Given the stakes for Mr. Williams, I could see him saying, I will not stipulate to the sun was down at midnight. And we'll work through that. Okay. Well, we'll just wait for Mr. Williams I still want to get something on the record about this.
And I have not seen Mr. Williams since the bond hearing, and so I want to make sure that it's on the record what the offer was and what he's facing if we go to trial.
We will do that the day of jury selection with me. I don't know how it works with Judge Emerson, but with me, the very first thing we do is say, tell me the offer. Do you understand the offer? Do you want to do that? No, I don't. Everyone sign the indictment again so that, because we work off a copy of the indictment. And so it will have been so freshly signed, the jurors could say, hey, look, I can make the ink smear. And we'd handle it that way. So that'll get on the record then.
Sounds good. Thank you.
Okay. What is the offer?
It's 25 years to serve with followed by life on probation. He is A and C recidivist, so he's facing life mandatory.
Okay. I'm pretty sure he and I have had that discussion before, but I'm confident that Ms. Primovic and he have had that conversation. Okay. All right. So Ms. Alexander, just let us know when he gets into a booth on the 7th floor.
Please. Oh, he's in there. He's 7 South booth 2.
Oh, great. Well, he may have been listening.
He was.
There he is. Mr. Williams, I did not mean to exclude you. Let me get your speaker on 7 South booth 2. Hey, can you hear me?
Yes, I can.
All right. Mr. Williams, we're going to get on the record in your case. It's 24 SC 001-511-01 because it was reindicted. I have Ms. Reimer here in court. It's Reimer and not David? It's now David?
Reimer is my married name. David's my maiden.
Okay, but you prefer Reimer?
Yes, Your Honor.
Good, that's what I thought. So we have Ms. Reimer for the state. Ms. Primovic is here for you. Mr. Williams, Ms. Wood is stuck somewhere else, but they're your trial partners on this case, both lawyers. You're here, and I don't know when you plugged in, but I was having a discussion with one of your lawyers, Ms. Primovic, and Ms. Reimer, the prosecutor, about whether we could get your case to trial starting next Monday. And it doesn't sound like we can. I'm going to get on the record why, and then I'm happy to field from you any questions. But as Ms. Reimer likes to point out, we can certainly try it on my trial calendar rather than this visiting judge's calendar that starts on Monday, because the state will be ready to roll on that date, which is only 2 weeks from now, not like 6 months from now. So here's where we are, Mr. Williams. And I may be repeating some things you heard. I just didn't know when you got in the booth. A central witness for the state is a Dr. last name?
Little.
Dr. Little. who allegedly performed an examination on the person who is the alleged victim in your case in chief. And as a result of that examination, he put together a rape kit. He supposedly sent it off to the crime lab. And that's one of the pieces of the supposed DNA matches in your case. And please appreciate, I'm using the word alleged or supposed in all of this. This is the state's version of events. I'm not saying that anything happened in this case at all, but it helps me understand why Dr. Little is important to the state's case. As I understand it, he's important in two ways. One, he is chain of custody. He would say, that's my signature on this bag that had the swab that ends up supposedly having your DNA on it.
Right.
Secondly, he's important because he's someone with whom the alleged victim interacted and he treated her. And so he'd be able to say there was a bruise here or there wasn't a bruise here, or there was evidence of this or not evidence of that. He's a doctor and he can talk about it in a way that you and I cannot. So he's important to the state's case. He also will not be in the United States next week, not because he's a vacationer, but because he's what we call a traveling doctor. And he's going to be working with patients not in the United States. He could, however, appear virtually like you are. And so let me add myself to the screen so we're all speaking on the same, here I am. So it would be like this, and the doctor would be there and the lawyer would ask the doctor questions. He would say, I examined the patient and did this. And your lawyer would be able to cross-examine the witness. And so we could actually have that conversation, but he would not be in person. The jury would be in court, you'd be in court. So we'd all be in one same space. And then there'd be this small head on the screen that's Dr. Little. You have an absolute right to directly in person, according to our US Supreme Court, confront witnesses called against you. And he would be one of those witnesses. The state would call him. And so what Ms. Primovic was telling me, but I'm going to have her confirm it in your presence on the record, is that you, through your lawyer, are objecting to any virtual appearances, to include Dr. Little. And that's your right. I might push back and say, but he's just a chain of custody witness. He's actually more than that. And it's your trial, it's not mine. So really my view on it doesn't matter. But you do have that absolute right to have the witnesses in court so that the jury can see them directly, so that your lawyer can get up close and personal and say, are you telling me this piece of paper really says that? However Ms. Primovic or Ms. Wood would handle it. And what Ms. Primovic, and it was initially Ms. Wood in some emails between the lawyers and myself, but Ms. Primovic here in court was saying, we do not waive the physical presence of any of the state's witnesses.
That's right.
And so Ms. Primovic said, this is what Mr. Williams and I talked about, and I'm not waving from that stance. And she did it very respectfully and properly and all that. So what I need you to understand is that given that, I'm moving the trial from next week back to my trial calendar, which starts on, everyone's saying March 13th.
That's the day we're in court, yeah.
Okay, whatever it is, that's my trial calendar. And so that's where this case goes. I needed you to hear that and Ms. Primovic to confirm it on the record so that I can let this judge who's visiting next week know, guess what? You're not trying Mr. Williams, you're gonna try a different case. Not one of my cases, but that's how the cookie crumbles sometimes. Ms. Primovic, is there anything you wanna add on the record before we wrap up this hearing?
No, Your Honor, and we'll be out to see him next week again to talk about everything again.
And the we is you and Ms. Wood?
Yeah, or just me.
Okay,
One of us.
got it. A lawyer of Mr. Williams will be there to see him to continue this discussion.
Yes, sir.
Okay, and Ms. Primovic, do you see any reason why the defense will not be ready for my trial calendar?
No, Your Honor.
All right, and Ms. Reimer, I've heard you say every which way the state will be ready.
Yes, sir.
Okay, I want to clear up one potential source of confusion because you keep saying March 13th, and March 13th is a day of the week. It's not coming up the way I want it to come up. So that's when we call the calendar.
Right, and my understanding to begin the 17th to 24th?
I'm going to look,
Okay.
But the fact that Dr. Little could be here on the 13th is unimpressive.
He will be here back on the 17th or 18th at night to start. So he's available starting the 18th and then available the week of the 24th.
Okay, I don't think it's that simple.
Okay.
But let me look. This is interesting. We could have it as a back up to, I have a civil trial calendar the week of the 17th.
Okay.
So that's like vacation for Ms. Dilligard. But there's no reason why we couldn't have this as a backup because civil trial calendars often fall apart. But it's not till the 24th is our first week of the criminal, and it's just 1 week. So, but I'm hearing you say Dr. Little will not be overseas the week of the 24th.
Yes, that's correct. He will be back in Atlanta for that week. He lives here. Well, he comes back the 18th, so I would never be able to call him until the 19th.
But we could do that trial. He just wouldn't go the first day.
Yes.
Got it. So either week, should we be back up to the civil trial calendar and be reached the week of the 17th works for the state. And more importantly, the official week of the 24th, we have a Dr. Little.
Yes, Your Honor.
Okay, that's very helpful. And Ms. Primovic, you and Ms. Wood are good to go either of those weeks.
I am, Your Honor. I'm especially set in Judge Richardson on the 24th, but we'll work that out.
Okay.
I mean, I will work out my availability.
You'll clone yourself like you usually do.
Yes, Your Honor.
All right. Well, then we've got a plan. Mr. Williams, your case will not be tried by Judge Emerson. That's the visiting judge next Monday. We'll find something else for him. And your case will remain on my trial calendar. And I'll let Ms. Primovic talk with you about whether you need to come over to court when we call the calendar. That's the 13th date we've been talking about. That's not a day where anything would happen with your case unless you're pleading guilty. If you're not pleading guilty, then it may not be necessary to bring you over here. I'm happy to do it, but not if your lawyers and you have already been talking. But I'll get that info from Ms. Wood. I just don't want you to be surprised if you don't come over on the 13th. If the answer is always it's a trial or bust, then we don't probably need to bring you over on the 13th. But I'll talk to your lawyers about that. They may want you to come over anyway because there's something we need to take up. And I'll be here. Ms. Reimer will be here. So that would be a time to bring something up.
Okay.
All right. Any questions about anything else at this point, Mr. Williams? Not about the facts of your case, but process.
I understand. No, I'm just ready to get this over with.
Okay. I think that's true for a lot of people involved. So we'll keep it moving forward. We just won't have you come over next week because there won't be a trial next week.
Understand.
Ms. Primovic, anything else on behalf of Mr. Williams?
No, Your Honor, and thank you.
Ms. Reimer, on behalf of the state?
No, Your Honor.
Okay, that's it. Mr. Williams, you are free to leave the booth. Appreciate it.
Thank you.
Take care, sir. We'll see you next week.
Do you have any issue with me replying all to the email chain about the, no, okay.
No. So that went very smoothly, Ms. Primovic. You have developed a good relationship. Thank you.
Thank you. Thank you, sir.
All right. I think we're done. Ms. Alexander, do you have anyone else you thought we were going to be talking to?
No, Judge. I think that's everyone.
Great. Well, thank you. Let me get off this screen. Appreciate your time.
No worries, sir.
And thank you, Ms. Jackson. I know you were on this whole time, but we didn't have any pleas. So here we are. Maybe tomorrow.
All right. Thank you. Have a great day.
All right. Thank you, everyone.